All prosecutors are different, but I do believe that some generalities can be made about prosecutors. And I think if you're a defendant, criminal proceedings will be a little less frustrating for you if you try to understand the prosecutor's priorities and his perspective on things. So the first generality is that every prosecutor has one main priority, and that is to do his job. So like all professionals, the prosecutor wants to do his job in a satisfactory way, and he wants to keep his job. So even though he has some discretion on how he operates, he still has to toe the line and go through his reviews, and he needs to do basically what he's told to do. In addition to this, he needs to protect himself and protect his job. So if he has a defendant in front of him who is, in the prosecutor's mind, a potential threat to the community or to a particular alleged victim, whatever it may be, the prosecutor is going to ask for what he thinks is an appropriate bail amount or a sentence that's fitting for the charges or whatever it may be, so that if the worst case scenario plays out and this defendant gets released and does hurt somebody, the prosecutor can say, look, I asked for X amount of bail or such and such a sentence, and he can cover himself and protect his job. The second generality is that prosecutors really do not take your case personal. So if you are being charged with a second offense, OUI, or drug possession or multiple shoplifting or whatever, the prosecutor probably has little to no animosity towards you. Now, this can change. Okay, you can irritate the prosecutor, and it can become a bit personal for the prosecutor. In rare cases, defendants will personally insult the prosecutor, either outside of court, or they'll even do it in the middle of proceedings on the record, right to the prosecutor's face. Now that does happen, but it's rare. I think the most common way that defendants get under the prosecutor's skin is by failing to or refusing to compromise. So often the prosecutor will seemingly just want to get rid of a case. He'll offer a very lenient plea deal, and the defendant, for no rational reason, will just reject it. And then the prosecutor needs to start doing additional work, and that often seems to irritate the prosecutor. The lenient deal will get taken off the table. A more draconian offer will be laid down. So that's much more frequent than the personal direct insults, right? And then the last generality to make is that prosecutors are extremely busy. They have a very, very heavy workload. I think if you went around the court, everybody would say that he or she is busy and think in their own mind that they're the busiest, whether you went to the clerk or the judge or the probation officer, whoever. But the prosecutor could have a dozen cases or 24 cases on any given day. More arrests keep coming in during the course of the day, and they need to, on the spur of the moment, come up with arguments and read their police reports, and sometimes they do those simultaneously. So you need to be aware of this, and you also need to be prepared to correct honest misstatements that prosecutors may sometimes make. Often there will be several police reports, and the prosecutor will select just one of them and essentially make his argument reading the police report. Occasionally things get misstated, or there's conflicts in the police report, and you as the defendant and your lawyer as well should be very familiar with the facts so you can correct the prosecutor on record if need be. Because sometimes a misstatement could tip the scale not in your favor, so you need to be aware of that. All right, I've written a blog post on this, and I'll put it in the description below.